Supreme Court dismissed the appeals in the matter of KP TAMILMARAN versus the state represented by Deputy Superintendent of Police and directed appellants on bail to surrender in 2 weeks in this case. Kannagi and Murugesan, both residents of village Puddukurapetai in district Kuddalore, Tamil Nadu, were in love. Murugesan had completed BE Chemical Engineering from college in Chidambaram, Tamil Nadu and was employed in Bangalore, whereas Kannagi was completing her BCom studies from same college. Knowing well that Vaniyar community to which Kannagi's family belonged would never allow their union, they got secretly married before registrar of marriage at Kuddalore on 5th May 2003 and got their marriage registered. After performing their marriage, the two returned to village and were leading a normal life with their respective families. But then in first week of July 2003, both left their village quietly without attracting any attention. By the time Murugesan was brought to village, it was evening. Thereafter, as per prosecution story, A1 to A13 undressed Murugesan, tied him to a post, and then he was mercilessly beaten by mob, including accused 1 to accused 30. This was done in full view of many villagers who were present there, yet there was no attempt to stop this savage brutality. A1 to A13 continued to torture Murugesan, compelling him to reveal whereabouts of Kannagi. After much physical torture and beating, when Murugesan was unable to bear it any longer, he finally revealed that Kannagi was in prosecution witness 23 Saroja's house, who was mother-in-law of A4. Immediately, Tata Sumo car was arranged by A1, which was driven by PW22 Jayatsaran, in which A4 to A11 climbed and proceeded to Mungilathaparittu village, where PW23's house was located, with intention of getting Kannagi back to Puddu Kurapatti village. Kannagi was finally brought to her village, and by this time it was 5:30 a.m. in morning. Both Kannagi and Murugesan were then taken to Cashew Grove near village. Once there, A1 gets Nuvacron 1, which is an insecticide or poison, in a steel tumbler and gives it to his son A2 and orders him to administer that to his daughter Kannagi. A2 then forced Nuvacron down Kannagi's throat, which caused her death in minutes. Prosecution story here though also suggests A2 tried to administer remaining Nuvacron to Murugesan, but when Murugesan resisted, this task was assigned to A4. All the same, court said we must note that this is version of prosecution that A4 administered or tried to administer poison to Murugesan was not accepted in view of evidence of PW49 Chinnapalai, stepmother of Murugesan, who had said that she saw A2 administering poison to her son Murugesan. Like Kannagi, Murugesan too died minutes after being forced to drink the poison. Court said that one of the many reasons for witnesses turning hostile is the long delay usually caused in a trial. This is again unfortunate but true in our country. The present case is no exception. Here, the incident occurred in the year 2003. The case was committed to sessions in the year 2010 and charges were framed as late in year 2017 and judgment was finally pronounced by the trial court on 24 September 2021. It took 18 years. In cases where the crime is committed at a residence or a place near residence of deceased, it is close relatives, court said, who are likely to be witness to the crime, their natural witnesses. From perusal of evidence in this case, it was also clear that accused before Supreme Court had brought Kannagi to Puddukurapetai village, where she was also killed by administration of poison along with Murugesan. There is a wide discretion, said Supreme Court, with the courts under Section 311 CRPC. These powers can be exercised suo motu or on application moved by either side. After all, object of the court must not be deprived of the benefit of any valuable evidence. It is absolutely necessary that courts must be apprised of best evidence available. Thus, courts have been given wide powers to decide on their own if a witness is required to be called or recalled for examination or re examination. In a case where neither party is interested in examining a person as a witness, yet the court feels that evidence of such person is necessary for just decision, court though cannot compel prosecution or the defense to call a witness, but it can invoke power under Section 311 CRPC read with Section 165 of Evidence Act and call such a person as a court witness. The courts are not barred from putting questions which may contradict the witnesses with the previous statements made before the police. Special powers of the court under Section 165 of Evidence Act are not impaired or controlled by provisions of Section 162 of CRPC. Powers of court under Section 165 of Evidence Act and importance of Section 165 in the meaningful conduct of trial is brilliantly explained by Justice O. Chinnappa Reddy with distinctive clarity of his letters in Ramchandar versus State of Haryana case. Justice O. Chinnappa Reddy goes on to say that a judge can ask any question in any form at any time of any witness or of the parties about any fact relevant or irrelevant. But then while doing this, judge must take both the prosecution and the defense with him. The purpose of an investigation, like the purpose of trial, is to reach to the truth. The duty of an investigating officer is to lawfully collect evidence. In present case, investigating officer not only covered evidence but fabricated his own. Instead of collecting evidence, he created evidence and tried to implicate innocent and set the guilty loose. In order to fulfill his wicked design, he has deliberately and willfully violated mandate of section 154 and 157(1) of CRPC as well as section 23 and 24 of Police Act 1861. Constitution Bench of Supreme Court in Lalita Kumari versus Government of UP case made it absolutely clear that an FIR can be registered even if there is no formal informant. In fact, it is obligatory for police to register the FIR when they receive any information which is sufficient to suspect that some cognizable offense has been confirmed. It is not the case that Lalita Kumari case had made registration of FIR obligatory for the first time. It was always there in the statute. Thus, even in absence of formal informant, police is duty bound to register the case whenever they receive any information regarding commission of a cognizable offense. Court said that in the present case, there is no doubt that accused 15 and 14 had the information regarding death of Murugesan and Kanagi on the day of the incident itself, that is 8th of July 2003. However, they did not register the FIR, thereby acting in violation of the provisions of law. Their defense that nobody came forward to lodge a complaint for registration of FIR cannot be accepted for two reasons. Firstly, when members from Murugesan's family went to the police station to register FIR, they were rebuffed and were given caste-based abuses. Thus, their plea that nobody comes forward to lodge a complaint is unsustainable in light of facts of the case. Secondly, court said that even if we assume for sake of argument that nobody went to police station to report the double murders, it was duty of A14 and A15 to register FIR as it cannot be doubted that they had information regarding the crime. Hence, their defense is unacceptable in light of law as well as in facts of the case as rightly has been disbelieved by the High Court. When public, political, and media pressure builds up, A15, 9 days after the double murders had taken place, manufactures an extrajudicial confession of A1 and registers the FIR against four Dalits, who were the family members of Murugesan, and four Vaniyars. A15 then went further and manufactured confessions of other accused. These facts are particularly glaring in the light of the fact that A15 knew about incident right from date of occurrence, that is 8 July 2003, but still took no action and made no effort whatsoever to uncover the truth. After analyzing provisions of law, following positions emerged in light of facts. A14 and 15 both had committed offences under Section 217 IPC and Section 4 of SC/ST Act as they neglected their duties and disobeyed law by not registering FIR at first instance with intention to save the culprits. Now, coming to role of A15, like A14, A15 was also guilty of offences under Section 217 of IPC and under Section 4 of SC/ST Act. But in addition to these wrongdoings, it is also borne out from record that it was A15 who was the main architect behind the FIR dated 17 July 2003, which falsely implicated four members of scheduled caste community. Further, it was A15 who was in charge of investigation, which led to filing of charge sheet against innocent persons belonging to Dalit community. There is no doubt, said Supreme Court, that A15 did this entire exercise to absolve culprits belonging to Vaniyar community of their complicity in the crime, and he knowingly and deliberately falsely implicated some of the Dalits in an offense punishable with death. Evidence, as discussed, makes it clear that A15 manufactured extrajudicial confessions and evidence and thereafter filed charge sheet against Dalits on based of that evidence. Hence, High Court rightly upheld conviction of A15 under Section 217 and 218 of IPC and Section 4321 of the SC/ST Act and sentence of life imprisonment. Court said there is no doubt in our mind that A15 is guilty of the offences as held both by trial court as well as High Court in appeal. Court said we have also looked into the aspect of victim compensation in this case. Crime is an act against the state, but a wicked and odious crime, as the one we have just dealt with, is ugly reality of a deeply entrenched caste structure. Honor killing, as these are called, must get a strong measure of punishment. We are also of the opinion that victim compensation here is warranted. Thus, the court awarded compensation of rupees 5 lakhs to PW1 Sammi Kannu, who was father of Murugesan, and PW49 Chinna Pillai, stepmother of Murugesan, jointly, or to the nearest of their kins.